Senator Dalphond.
Merci, Monsieur le Président.
Thank you, Mr. Speaker.
Colleagues, I rise today to speak to Bill C7 at second reading, a parliamentary step that is defined as follows in the House of Commons Procedures in Practice, second edition 2009, I quote, "Central to the second reading stage is a general debate on the principle of a bill. Although the standing orders make no specific reference to this practice, it is deeply rooted in the procedural tradition of the House. Accordingly, debate must focus on the principle of the bill and not on its individual provisions." End of quote. In other words, our vote at second reading will either be in support or in opposition to the principle of this bill, which is to expand access to MAID. This bill stems from a judgment of the Quebec Superior Court rendered on September 11, 2019, that rejected the arguments of both the Attorney General of Canada and the Attorney General of Quebec about the validity of one of the eligibility criteria for MAID, called the reasonably foreseeable natural death criteria in the Criminal Code and the end-of-life criterion in the Quebec Act respecting end-of-life care. Those here in June 2016, when Bill C-14 was adopted, will remember that the majority of senators agreed that this criterion was contrary to Section 7 of the Charter of Rights and Freedoms. On Section 7, the Supreme Court of Canada said in 2015, in the case of Carter versus Canada, a unanimous judgment, and I quote, "We do not agree that the existential formulation of the right to life requires an absolute prohibition on assistance in dying, or that individuals cannot waive the right to life. This will create a duty to live, rather than a right to life, and will call into question the legality of any consent to the withdrawal or refusal of life-saving or life-sustaining treatment. The sanctity of life is one of our most fundamental societal values. Section 7 is rooted in a profound respect for the value of human life. But Section 7 also encompasses life, liberty, and security of the person during the passage to death. It is for this reason that the sanctity of life is no longer seen to require that all human life be preserved at all costs. And it is for this reason that the law has come to recognize that in certain circumstances, an individual's choice about the end of her life is entitled to respect. End of quote. However, the government and the House of Commons declined the Senate's amendment, and the Senate finally decided not to insist. As expected, the criterion was quickly challenged. Only 10 days after the passage of Bill C-14, Julia Lamb, a woman in her 20s with spinal muscular atrophy, and the BC Civil Liberties Association launched a constitutional challenge before the Supreme Court of British Columbia. On June 13, 2017, another challenge was launched before the Quebec Superior Court by Jean Truchon and Nicole Gladue. Monsieur Truchon était alors.
At the time the ruling was given, Mr. Truchon was 51 years old. Since birth, he had been suffering from spastic cerebral palsy with triplegia. This condition left him completely paralyzed, except for his left arm, which was functional and allowed him to perform certain daily tasks and to move around in a wheelchair. Mr. Truchon chose to receive MAID last April. Ms. Gladue, now 74 years old, was born before the widespread availability of polio vaccine inoculation. She contracted an acute paralyzing form of polio at age 4 and survived. However, the disease left her in a coma, from which she emerged with significant lasting consequences, including residual paralysis on her left side and severe scoliosis caused by progressive spinal deformation. The trial was held in 2019, and it lasted 31 days and over 2 months. A total of 25 witnesses, including 17 experts, were heard. 7 psychiatric experts testified, including the Council for Canadians with Disabilities, the Canadian Association for Community Living, the Christian Legal Alliance Physicians Against Euthanasia Collective, and Dying with Dignity Canada. They also testified before Legal and Constitutional Affairs 2 weeks ago. In September 2019, more than 2 years after the legal proceedings began, the Quebec Superior Court handed down its ruling. And that is normal for a file of this nature. Concerning on the impending death requirement, the Quebec Superior Court judge wrote, and I quote, "The government-imposed restriction that death must be reasonably foreseeable before one can seek medical assistance in dying is overly broad in scope, since it prevents certain persons, such as Mr. Truchon and Ms. Gladu, who are capable and knowledgeable, who meet all other protective conditions of the law, and who express a rational desire to end their suffering because of their serious and irreversible condition, from seeking such assistance." In this sense, the restriction goes far beyond the intended objective, that it has no genuine connection to the objective of protecting vulnerable persons who might be induced to end their lives in a moment of distress. Rather, it forces them to make the cruel choice referred to by the Supreme Court in the Carter decision, in that it forces them either to suffer intolerably for an indefinite period of time that may last months or even years, or to end their lives on their own, all in order to satisfy a general precautionary principle. End of quote. It is interesting to note that the Superior Court's reasoning is similar to that recently applied by the Supreme Court of Canada in a recently released judgment in Ontario, Attorney General versus G, which Senators Gold and Cavagnon referred to in their excellent speeches. I will come back to this at third reading, but for the moment, I will focus on the principle of Bill C-7, namely the broadening of access to medical assistance in dying.
That at the time of the Truchon judgment, we were going through a general election. In fact, Parliament was dissolved on the same day the judgment was released, on September 11, 2019. On October 3rd, the Quebec government announced that it will not file an appeal. A week later, on October 10th, during the French electoral debate, Prime Minister Trudeau made a similar announcement. In other words, both governments decided not to avail themselves of the right to appeal the judgment before the Quebec Court of Appeal. And most likely, a ruling by the Quebec Court of Appeal on this matter is one cases for which leave will most likely be granted by the Supreme Court of Canada. Some witnesses and some members of this chamber believe that not appealing was unwise. While I respect your opinion, I do not share it. Of course, filing an appeal will have buy time for both governments, a few more years to avoid making a decision pending an appellate process up to the Supreme Court of Canada. Instead, both governments decided to face the music, well aware that at the end of the day, it falls squarely on lawmakers, not on the courts, to define to what extent aid should be made available and what safeguards should be implemented. Of course, these eligibility criteria and safeguards adopted by Parliament or by a province must not run must be in compliance with the Charters of Rights and Freedoms. In this regard, the institutional roles of both courts and parliaments are different, as the Supreme Court said recently in Ontario versus G. I quote, "The legislature is sovereign in the sense that it has exclusive authority to enact, amend, and repeal any law as it sees fit, while courts remain guardians of the Constitution and of individual rights under it," end of quote. Colleagues, we often hear that politicians are hiding behind judges' robes to avoid making difficult decisions. But this time, both governments decided to act. They did so in consideration of the teachings, not only of the Quebec Superior Court in Truchon and of the Supreme Court of Canada in Carter, but also of this Senate in 2016. Why? Well, the answer to that question was repeated many times. It is because both governments believe in the principles of autonomy and equality of individuals, including the right not to be forced to resort to other inhumane options like voluntarily stopping eating and drinking, or the use of a violent means to put an end to their enduring and intolerable suffering. All Canadians were made aware of the Trudeau government's decision, and Canadians had the opportunity to question all candidates about the decision not to appeal Truchon, and thus the very decision to expand access to MAID. Last week, those elected in this last general election spoke loudly and clearly. Bill C-7 was adopted by 213 of them, opposed by 106 of them. It is important to note that this 2-to-1 majority includes members of all the parties in the House of Commons, including 13 Conservative MPs, all Bloc and NDP MPs then present, all Green MPs, and nearly all Liberal MPs. This is quite significant, considering the nature of the bill, its complexity, and the larger set of difficult issues it raises of legal, personal, social, and ethical nature. Colleagues, it is against this background that we are now called to vote on the second reading of Bill C-7. I know some of you, like many witnesses at the Legal and Constitutional Affairs Committee that we've heard from, are opposed to MAID in any form whatsoever. I respect your opinion, but Bill C-7 should not be viewed as another opportunity to oppose MAID in principle. As the Supreme Court has stated, the government has a constitutional duty to provide access to MAID to Canadians who want to put an end to their enduring and intolerable suffering resulting from a grievous and irremediable condition, and who wish to do so peacefully, in a safe setting surrounded by their loved ones. It is a matter of respect for the dignity and autonomy of all citizens in a democracy. For these reasons, I will vote yea to the second reading of C-7, a bill that seeks to end denying a constitutionally protected right to many Canadians under Section 7 of the Charter. That doesn't mean that I don't support every part. That doesn't mean that I support every part of the bill. As you know, I have expressed serious concerns about the proposed exclusions of individuals with a mental illness as a sole underlying condition. Others may wish to have more safeguards in connection with specific situations. Thus, I look forward to debating the various measures proposed in Bill C-7 with colleagues at committee and at third reading. Thank you. Merci. Miigwech.